Judgment WPC number 13452 of 2026.
The summary show cause notice accompanied by demand show cause notice, order in original, raising the demand under section 73 of the CGST and OGST Act pertaining to financial year 21-22 are quashed, and the matter is the proper officer is to now
Matter is remitted back for a reconsideration. Yes. Uploaded in the form of a
it
judge.
is not actually remitted back, but he will see that whether proceed because that
For reconsideration.
for reconsideration by legal aids.
Item number 2, WPC 36978 of 2025.
We have quashed office order dated 15/12/2025 and matter is remitted back to the authority concerned for consideration.
You belong to the okay, that's why I say water logs the right. You belong to the okay, that's why I say water logs the right.
It's a common phenomenon that comes from areas are there.
Why there's a clogging of the drainage system and all everything by an encroachment?
Earlier, it was filed on the same allegation, and direction was given to Municipal Corporation Nalgala to look into the matter and constitute a committee. They have constituted a committee and they have taken steps. In spite of that, this has been happening. So now the present position is this, in spite of the work undertaken by the.
So they have already taken a steps, constituted a committee. They are taking steps for removal of the encroachment.
Well, lots of they have taken step and filed an affidavit in this court in 2023. Page 23, Lordship may see it for a moment.
Yes.
Page 23, what is the condition?
No, I understand.
Yes.
So
It is not functioning now. There has been a standing order of the state government annexure 1.
For monitoring.
RBC say the public accounts committee, they have to submit the report periodically to the public accounts committee. There is standing order from the government of Odisha. Page annexure.
what the municipality is doing?
Municipal corporation.
Municipal corporation.
See, they also filed affidavit on the basis of the report. The last time the contempt was also dropped. Expecting that the authorities will continue to monitor this. But again, encroachment has come on those areas. Those are all
Notice to the municipal corporation. Notice to the municipal corporation.
Corporation, collector and.
yes.
Oh, that is what is a
Once
collector.
is that collector is in charge of this.
He is representing the
Yes,
collector.
Well,
Item number 2.
Hearing in
This has challenged the constitutional propriety and legal propriety as well as the fiscal sustainability of Subhadra Yojana and Mukhyamantri Kanya Vivaha Yojana, two schemes sponsored by the state government. They are withdrawing the funds from the consolidated fund, which is unauthorized, which is violative of Article 266(3).
No, your prayer is to discontinue with the Subhadra Yojana and Mukhyamantri Kanya Vivaha
Yes, my
Yojana.
lord.
Well, it's a policy decision of the
No,
government.
policy decision.
What the court has to do? Why to ban it?
This is not a policy decision. There is
Why?
no legislative sanction behind
It
it.
is not required, sir. Does it require any legislative sanction so far as the policy is concerned?
Then
It is within the directive principles. If they have taken a decision,
a government can take a decision to make withdrawal from the consolidated fund and distribute.
that is if it offends,
Right.
Mr. Counsel, if it offends any of the constitutional provision or
Yes,
it offends any of the statutory provision, I can understand.
yes.
But so far as the policy decisions are concerned, there is
This-
hardly any scope
This
under Article 226 to interfere.
This is not a policy. This
To
is
ban.
my lord.
No, your prayer is to ban these yojana.
Yes,
Look at your prayer.
yes, my lord.
What is this? These are the policy decisions the government has taken. You have not stated
My
anything.
lord, the policy
Regarding
decision
what you have
cannot
not
be
stated
taken
anything.
against.
Nothing of the kind. Pond. Where is the case made out by you? Show us.
Policy decision cannot be taken against the constitution.
Sir, I am asking you, you are making out a case where you have made out in the pleading. Show us. Show your pleading you have filed. Show me that where you have made out a case.
Yes, sir.
Show us.
My lord. In which,
Please.
in this case, actually, the government is ransacking the state exchequer through unconstitutional and illegal withdrawal in massive scale from consolidated fund of the state and misusing the public money for enhancing electoral prospect, my lord, and
What?
for empowerment of women. But actually, this is not empowerment of women. For empowerment of women, at least for human entrepreneurship, the government can make a policy, but not.
Where in the case?
You were talking of fund.
Oh, fund these. I said pond.
No, fund. He's saying that this scheme cannot have this.
You any welfare policy to uplift the
Yes.
economically stricken
Yes.
section of the society,
Yes.
that should not be done.
No,
The
that
government
should be
should not
scientific.
spend a single penny. They cannot take any
No,
policy
That
decision.
should be very scientific. Not
What is a scientific manner, sir? If the government has decided to provide some kind of a monetary sustenance to a section of the society, it is what is a policy decision of the government.
To develop a tree by culture.
But where is your petition articulated that way? You must have to articulate that way, no?
No, this cannot.
Yes, my lord.
Is a fund is with
My-
them, it is within
Yes,
their
but-
domain to take a policy.
They have sanctioned good policy.
My lord, para 11.
This fund-
Para 11, my lord.
Show me
It is-
one judgment of any court that the government cannot spend any money, even a single penny, for the upliftment of any section of the society, even on account of a gender.
For upliftment, my lord, there must be a particular scheme which will.
Show us one judgment.
Not
There is not.
pocket expenses.
Here I find that
Cannot
everybody is
distribute
talking
money for
about a
pocket
scheme.
expenses.
Sir, the
Right.
policy does not come. It is not a question of any scheme to be framed under the statute. It's a policy decision which is independent and which has been passed by the cabinet, which has not been.
266.
Yes,
Article
you
266.
the constitution.
Article 266.
He's a lawyer himself. Appears. Yes.
266(3).
Show us, sir.
No money out of consolidated fund of India
Yes.
or the consolidated fund of the state shall be
Yes.
appropriated except in accordance with
Which article you are reading? It is not that. No money from where you are reading, sir?
No money. See, 266(3).
No.
Yes.
Yes.
No money out of consolidated fund of India or consolidated fund of state shall be appropriated except in accordance with law and for the purposes and in the manner provided in this constitution.
Correct. Come to chapter 4, part 4 of the
So let us
Constitution.
go to,
Come to part 4 of the Constitution.
yes, part 4 of the constitution.
Please come.
Yes.
Yes.
Part 4, sir.
Yes.
Duties.
Yes. Sir, come to Article 38.
30.
Yes, sir.
State to secure social order
Yes.
for promotion of welfare of the people. The
Yes.
states are strive to promote the welfare of the people by securing and protecting as effectively as it may in a social order in which justice, social, economic, and
Economic.
political shall inform all the institutions.
Yes, economic. Then
Yes.
come to 2.
Yes, the state shall in particular strive to minimize the inequalities in income
Sir,
and endeavor to eliminate inequalities in status, facilities, and opportunities, not only amongst the individuals, but also amongst the groups of the people residing in different areas or engaged.
what does it mean, sir?
But without fixing any eligibility
Sir,
criteria.
what are you talking about? If they say, they can make even under part 3. Under part 3.
Can be eliminated by distributing money without any fixing any eligibility criteria and all that.
Anyhow, I can't make any comment on that. You continue. Have you read Article 15, sub-article
Yes,
3?
15.
Sub-article
For
3.
women and children, this government can make special provisions, but not
What does it
based on
mean?
blanket cash goals.
What does it mean?
To make some schemes to for a human.
Sir, if they have floated a Subhadra Yojana where they wanted to uplift the woman
Subhadra was
inequalities
Listen.
and the economic disparity which the woman faces in the society. Where do you stand in the way? Don't be anyhow.
if randomly government distributes money.
Sir, randomly there is the policy. The policy is very much laudable. That some of the women's section of the women's society, they need those requirements.
Why not notice may be issued? Let them.
What is wanting in your application is with regard to the disparity that you are saying. No, there is nothing has been made in this scheme according to you, no identification, nothing. Where is that? In absence of all those, how can you simply make an allegation? What is the document you have annexed to that?
No. If you look at the guidelines, they have fixed the eligibility criteria. It is not that's the indiscriminate distribution. They say the woman beneficiary must meet the following eligibility criteria to avail the benefit of the scheme. What? Must be a resident of the Orissa, must be covered under the National Food Security Act, State Food Security Scheme. Any woman from a family without such and such can apply under Subhadra if her family income is not more than 2.5 lakhs per annum.
But
What are the eligibility? What more?
but there is no grievance redressal mechanism.
This no grievance mechanism is not there. If they apply, they apply.
My
Grievance is a clause.
my lord, this is based on cabinet decision only.
Clause
Grievance is
10.
there. Clause 10 is there. Have you gone? Grievance. Go to clause 10. Clause 10.
Yes, grievance is there. There is the broad head of the grievance.
To provide a quick and people-friendly mechanism for receiving people's grievance and statutorily responding to them.
Everything is there.
Centralized call center is there. There are other mechanisms.
Whether this is something which is. Come on, sir.
My lord, this is the violative of the provisions. I have already cited the
Yes.
provisions violated by the scheme.
That's all.
If an unconstitutional scheme can operate, then I have nothing to say.
I do not know where is the unconstitutionality in the scheme.
I have pointed out the.
You have pointed out Article 226 that the consolidated fund.
Yes,
What is a consolidated fund? Tell me. Now let us examine what is meant by a consolidated fund. And what is a fund which is allotted by virtue of a budgetary allocation? Tell me. Is the budgetary allocation comes within the consolidated fund?
yes, but
It's come.
yes,
Sir, I will learn afresh.
my lord.
The consolidated fund is outside the budgetary allocation.
Yes, my lord. The budget only consolidated fund is only meant for all the public monies received by on behalf of the government of India or government of the state shall be credited to the public account of the India or public account of the state, and no money is out of the consolidated fund of India.
That is what I'm saying, that what is the meaning of the word consolidated fund? Are you aware?
All the revenues received by the government of India, all loans raised by the government.
That is what I'm saying.
Yes, my lord.
That is what I'm saying. It is something which is different from the other funds.
Yes, my lord.
Are you aware of a contingencies fund as well? There are various types of funds which the government has.
Yes, my lord. But so far as the consolidated fund is concerned,
And all these salaries and allowances of the constitutional authorities are charged under the consolidated fund, not from any other fund.
but my lord, there should be an appropriation law.
Have you seen
By the legislature.
Article 215, so far as the High Court is concerned, how the salaries are paid, from which fund? It's from a consolidated fund.
Yes.
Otherwise, the
That
government
is- that
cannot
is-
run.
that is-
If
that
every
is-
individual comes
that
and
is
say you
absolutely-
can't allot this money in this, you can't allot money in that, government will not run. Cannot. The minister claiming themselves to the public.
Thank you.
Very clumsy, sir. Which is your place?
My lord, my case is, my lord, the petitioners are belongs to the Sangha Gram Panchayat. They are having, there are 7 to 8 villages. They are mainly dependent upon the agriculture, my lord. And they depend upon the stream water flowing from Chautandi, my lord.
Flowing from the.
And that
source.
has been blocked by erecting a dam, check dam, and diverting the water, thereby causing obstruction for the agriculture. That is our main grievance, my lord. We are unable to get the 200 acres of land, agriculture land.
Belonging to whom?
My lord, 7 to 8 villages, my lord. And some of the villagers have come up before
Are
the
you
law.
not getting an adequate amount of water? If they channelize the water,
But they're blocking.
can we visualize what is the purpose and object behind the construction of a dam?
My lord, they are
That
diverting it.
Water
to
does not
a
flow
different-
throughout the year. There are less number of water which comes during a particular season. There is a huge amount of water that is there. So that is what they accumulate so that it is an equally distributed
But
across
what has happened? What has happened
all the year irrigation the purposes.
for that? But without any alternative arrangement or
There is no
providing
question
that
of any
facility.
check dam means there must be some kind of a thing, but they must be flowing the water. It is not that that channel or a canal is completely dry.
But it is blocked by you.
No, it's can't.
So,
Mr. Soy, what is,
that?
you can't block it, you
You
can't.
can't build a dam. Dam is purpose of providing water to
Well,
everyone.
I understand, but so far as this canal is concerned,
Hmm.
there should be a continuous flow of water.
that-
It should
that's
not be of that amount, but there should be some amount which is sufficient enough for the irrigation purpose of those
Only
purposes.
for that, for this panel irrigation department has done this. It is not
Why
that-
they have done it?
Because it has to go.
No, I understand, but you can't stop the flow of water from that canal.
Stop.
He's saying that it is a complete
Yes,
stoppage of the water.
That is the difference.
These were
Let
done
them respond
1 year
to
back.
that.
1 year back. And now they must be getting
In
water
the
now.
September, my lord, they have.
No,
He must be
that's-
getting water, will not do. If he has come forward and say, I am not getting any water,
that.
then he will have to. So,
They say only.
you got the photographs of the check.
No, what is their
That
allegation is-
photograph I don't have. I have another.
You should.
Map which
No, the map is.
indicate that how the water is flowing.
Sir,
Yeah.
water, when you say that they have to put a check,
My lord.
and you say that they have completely stopped the water,
Well,
then you should show it that
my
it
lord,
has
I'll come up,
stopped
my
the
lord. I'll
complete
come up with
water.
the-
Mr. Rao, have they already gone for?
Yes, my lord, they have started,
Yeah.
my lord, in between, my lord, they have floated in the month of September. In between, my lord, they have already started, my lord, stopping the water and.
Without floating a tender, without avoiding.
Tender they have floated, my lord, they have,
Yes.
tender they have floated,
Yes,
annexure three.
Then they have not started the construction.
The construction they have started, that
How
is
can
why,
it be?
my lord, that is why, my
How
lord.
can it be, if you have floated a tender for construction, how can it
Annexure
start a
three, my
construction?
lord.
Remember in 2025.
September two thousand
No,
twenty-five.
finalized.
Yes, my lord.
That instruction I don't have what has been done.
That-
And what is their allegation also can see the representation. They say only the 2-3 villages are infected with the entire land.
7 to 8
Based on the
villages.
15th.
Their entire allegation is that They are the 2-3 villagers. They are only entitled to get the water, not any other village.
No, it is not that, sir.
That is their representation. That is their
case
representation with their
Their
percentage.
case is that they are not getting a water at all.
That they are saying now, but the representation is in
Sir,
Odia.
what is
Page
this
18, page
statement
18.
in the
Page-
petition? You just show me.
Page 18 of their representation itself speaks. Page 18 towards 3-4 lines, last part. Last part. କାଞ୍ଜିଆ ଗୋଳରୁ ବଡ଼ସୁଙ୍ଗା ଗ୍ରାମ ବଡ଼ ପୋଖରୀ ପର୍ଯ୍ୟନ୍ତ ଚଉବନ୍ଦୀ ମାହାରା ନାମରେ ରେକର୍ଡ ହୋଇଛି। ଏଣୁ ଚଉତଣ୍ଡି ମାମଲାର ପାଣି କେବଳ ତୁଳସୀ ପଶି ଏବଂ ଉପରୋକ୍ତ ଦର୍ଶାଯାଇଥିବା ଗ୍ରାମ ଗୁଡ଼ିକର ଅଧିକାର
Not 2-3 villages. It's a good number of villages. Natural source of water.
they will definitely get that.
Perennial source of natural water, which they used to get up to the month of December,
Yes.
as it said.
Yes.
Now that if the check, their apprehension is that if the check dam is put there, they may not be in a position to get the.
Please come with a scheme and tell us that what is the objective.
Yes.
No doubt about it. If there is a regular flow of water, there is no difficulty that they can raise any objection in this regard. Yes, the state is direct.
The aforesaid writ petition in the PIL category filed by the petitioner for the specific and proven interest of the newborn babies as well as infant up to 2 years. In the state, the petitioner earlier approached to the Department of Women and Child
Not
Development,
actually.
It was given, come directly.
not state properly not in the force IMS Act 1992.
What?
IMS Act 1992. IMS Act, Annex 2, my lord.
So what happened? They said,
My lord, according to this act, rule number 2 amendment of the section.
I am really surprised
there
here.
is nothing in your application. What is your grievance?
Actually, this is the memorandum application filed by online.
No. What is your grievance?
They have gave this receipt. Application already taken by them. Annexure 1 this is and Annexure 2 is the act.
Sir, I tell you very frankly, after reading your reading, that's my incompetence, I must say. I could not understand the head and tail therefrom. That's my incompetence. I do not say that you have not.
I am
I
coming.
was unable to understand. So,
Millard, I am coming.
now please, so that
Hello.
your competency will definitely erase my incompetency in this regard.
Nowadays, I am coming to simple words. Nowadays, in the society,
From the petition, what you have said.
Yes.
Please. Yes.
nowadays in the society, there are actually the milk substitute, which is powder milk. We are saying actually made for the babies who have actually orphan or not able to
Have mother's feet.
mother's
Huh.
feed.
What are you?
But
Huh?
this mother's feed, this jo powder milk, easily available in the stores, which is not remedies of the society.
Why?
The act is saying that.
Why?
The act is saying that you cannot advertisement, you cannot sell easily available in the society. Actually, for the
That
orphan,
case you have not made out.
yes, I
That's
have
why I'm
read.
saying,
I have read.
Show us from any.
petition, in the
Please,
petition.
Show us. Show us, sir. I have, that's why I say my incompetence. I appreciate and acknowledge your competence.
Point number
Give
3,
me-
Miller.
Which one?
Petitioner, page number 4, point number 3.
Point number 3, sir, what you
That
say.
the petitioners are filing the present petition on their own and not the instance of someone else. The
Correct.
litigation cost
Like that.
blah 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 and born by the petitioners themselves, and this is in the interest of up to 2 years and
What does
affected
it
children
mean,
in
sir? What
fact.
you are saying and what it is written,
Under
is what
IMS
I-
Act 1992.
that's
Then 4.1 point
yes, sir.
that the newborn infants of the state, along babies with age 0 to 24 months of children already affected by using of infant milks, substitute violations IMS Act instead of breastfeeding is the root cause of ongoing physical, mental, and critical illness like malnutrition, allergy leading to childhood asthma,
Where
pneumonia.
are the studies which you have
Yes.
indicated
Yes,
that
What
there
is
is no doubt about it that
Yes.
the mother's milk
Miller.
is the best nutritious food for a neonatal children.
Miller.
No doubt about it. But there are certain cases where either they are unable to generate the adequate amount of a milk for the for sustenance of the neonatal child, or there may be other factors, medical factors which may not. Do you think that in such situation, no supplement, milk, food, or a powder or a milk will be provided? Let neonatal die, not
No.
not invited in the society, let him go, because without the mother's milk, he will not. No other thing can be given to him. What you propose?
No, no, Miller. Actually,
Then what?
I am saying that
Then what?
that
Supplement.
That is-
It
this
all
powder milk-
depends upon the situation when a doctor prescribes or whether it's to be given, not to be given. These are all clinical what is this? Pathohistology
pathological studies.
studies, all these things will come. It's not a blanket one that you say,
Miller, this is
stop supplying the powder milk to the neonatal child.
no. This is
What
You
is
want restrictive.
restrictive area.
So this is what is there. Everywhere in the society, it is said that no, that's the best food for a neonatal child.
But easily available.
No,
in the
sir,
society.
easily, what is the meaning of the word
Easily
easily available?
It is seen that
Sorry,
Miller,
sorry.
a laborer also giving to his child powder milk.
Sir,
What the act says? Does it say that? it
Though
cannot be
the act is totally same. Please come to the act. Page number 10. Inappropriate feeding practices. Point number 2. Inappropriate feeding practices lead to infant malnutrition, mobility, and mortality in our children. Promotion of infant milk substitutes and related products like feeding bottles and kits to constitute to a health hazard. Promotion of infant preservative than the
next. Yes, the same thing. Our judgment are there. Butcher land, how can you without the reservation?
No, we are encroachment. Allegation is the encroachment has
Government, what are you doing?
after instruction.
What of the instructions?
The allegation is that some unscrupulous person has encroached the government land, butcher land, and they are not able to. Encroaching unnecessarily, they are encroaching, you want
No, I
to
will
remove her.
not take any steps against the
I will appear instruction for the removal.
Public interest education, lacking the Yes, madam.
We have seen the guideline issued by the Central Pollution Control Board. The polluted fat has been established within the vicinity.
What guideline?
Central Pollution Board Control Guideline. That is Annex to 1.
Yes.
The lordship can be told to Annex to
Why you want to want against the poultry farm?
because my lord, it is established in the vicinity
Are you
of.
a vegetarian?
I am a vegetarian. That's all. I'm not standing on the non-vegetarian.
Yes.
My lord, that is your lordship may kindly turn to page 25. Item number 7, tipping criteria.
Now, what is this Central Pollution Control Board has issued a guideline.
Guideline.
So,
For establishment.
what is the implementation of the guideline?
Yes, that has not been implemented. They have established the poultry farm, denoting all these criteria, and for which I am before your lordship, which creates the air pollution, water pollution,
Oh,
because it is in the vicinity. Your lordship may kindly.
air pollution, just tell me why.
Because of the farm, some pungent smells are coming. Some pungent smell are coming because people of the locality are being affected by that. The Sarpanch is before your lordship. Sarpanch of the village Gram Panchayat is before your lordship.
Can you?
Unable to. My lord, unable because of
I'm
the.
asking you, can you maintain? We have decided one case.
My lord, being the representative of the people.
No, sir, madam. Have you gone through the judgment? Where is Miss Das? Where is the judgment? Subject to my brother agreed. He was not
Let
there,
me
but
go
I
to-
was a part of that judgment.
President Pradhan, Reputation Civil number 18389.
Yes.
Let me go through it. The lordship may keep it to next week.
Please
Let me-
give her.
Yes, that I will do.
You know,
But I am a genuine grievance.
whatever, that is what I will say.
Let me, I can do by filing some other.
Please,
Yes, that I will.
go through that.
Yes, I will. Lordship may keep.
Give her a number.
183.
The lordship may keep it to next week.
Yes.
Item 7.
So bless.
May please, your lordship. May please, your lordship.
Just 1 minute.
Lordship, the better.
Just 1 minute. 1 minute. Let us go through 1 minute.
Yes.
So what kind of a PIL, sir, if they have initiated a proceeding for de-reservation of a category of the land into another category, then the remedy lies under that act itself. So you can go and challenge that order of the authority. How can you come and maintain a PIL?
We are not challenging that. The traditional.
That is what it
pathway-
says. You say that how can they convert the Gochar land into an industrial land? That must be by virtue of a particular proceeding.
Yes, that's
So
absolutely.
you, if you are aggrieved by such conversion, then you go and challenge
No, no,
it
no.
in accordance
We are
with the
not.
law.
We are not agreed. We are not agreed by the conversion.
Then what
We
is
are not-
what you are aggrieved by?
Your lordship, the traditional pathway for the farmers to their agricultural land has been blocked by the construction of the boundary wall. That we are agreed by, and we are only praying that.
Then how it partakes a character of a PIL, sir? It is a simpliciter writ petition in that sense. It does not contain, the character
And
of a
that-
PIL, sir.
And that.
What is the directive principles under part 4? What is the violation under part 3? Tell us.
We have approached the collector.
Right of way.
The Tahsildar also visited the
Let them
spot.
go. You have still a right, but you'll have to go before the other bench.
If your lordship pleases, then I will move before other bench.
No, how can we treat it as PIL? That has to go.
If the farmers at large are affected, your lordship.
No, I understand, but that is by a action taken in accordance with law. You are challenging that action.
No, we are not challenging that conversion part, your lordship.
Then how you are affected if you are not challenging? So you have a right to challenge under the specific act
As your lordship.
if you are an affected person.
Lordship, we have no road access now to.
And that is not, you have contended in para 8 also.
Yes,
Right
your
of way. Right of way.
Right of way.
That's the easementary right. You can go and assert your right. PIL.
Our cultivable land in imminent danger, your lordship.
Whatever, sir, you have a remedy, but this PIL cannot be misused in this manner.
And 7 families don't have any road access to.
Sir, that is what is there. That's why I'm saying that you will have to assert your right somewhere in the forum, which is provided in the statute. Exhaust the forum.
Immediately, we don't have any.
What are you talking about, sir?
It's a cultivation season is beginning, your lordship. We cannot.
That does not mean you are asserting you wanted a declaration of your easementary right through a PIL.
It's a public at large and affected. And
So what? Where is the public at 7 families you are talking about?
7 families and all the farmers.
No, sir. All the farmers are not there. Everybody is affected.
Your lordship.
It is a large tract of land and everybody is affected by a small boundary line.
I have given all the
No,
RRs
sir.
of the.
Sorry, we are
farmers.
unable. Sorry, we are unable to.
I have given all the ROR of the farmers.
No, sir. It's not.
Your lordship.
That's why I'm saying, sir, your right emanates there from. You go and assert your right somewhere in the forum. Right of the easementary right.
As your lordship pleases. Your lordship may observe that.
No, what observe? We will dismiss it. It's a clear abuse of the process of the court.
People, the poor farmers.
No, whatever, that does not mean. I understand that.
That life, but they cannot cultivate. This year, they cannot go to their field, your lordship, for cultivation.
The
Right. So to PIL.
This is registered because of the judgment of the Supreme Court. So now,
The report is to be submitted, but also grant some time for the report is to compliance with the order of the honorable court.
yes,
The report is to be submitted. As per the direction of the honorable apex court.
I believe that it should not be restricted to a particular category, but it should also be expanded. Though this the judgment is delivered in relation to a stray dogs on the street, but there are stray cows and the bulls roaming freely on the main arterial road. What are the steps taken by the government in this regard?
Grant some time.
I think every members present in the hall courtroom have experienced that.
Everybody.
So what steps are being taken by the government in this regard? Why not that issue be also taken?
The PIL.
This is though it is in terms of the judgment rendered in a stray dogs matter, but why not we expand it? Absolutely, the buffaloes, the cows, the bulls. We should. Yes. I agree. If you agree, then we will. The instant public interest litigation is Yes, registry to supply a copy of this copy means it's only a judgment, nothing more than that. It's only a judgment.
With the National Highway here.
Huh?
These issues are also there in the National Highway. It would be an issue.
And another
At
PIL.
least from Cuttack to Bhubaneswar, because the Cuttack PIL bench is only handling Cuttack. So they cannot go beyond.
It does not mean that the Cuttack PIL means that every relation to a matter will go to the Cuttack PIL. No.
This one.
This is a more larger issue concerning across the state. It is not restricted to a Cuttack, but many other major cities of the state of Odisha. We have to take. And a lot of accidents that took place, they have to.
We concern.
So what is the spectrum we have to take in this?
I think this Suomoto PIL, which is registered, only contains that judgment of the Supreme Court. If you want, we can supply you a copy of the judgment.
We have a copy. We take it.
No, it is here. We can, because we can supply you a copy. Is given. So let the copy of the writ petition be.
This public interest litigation is filed to set 5 acres of valuable jungle land, forest land, being grabbed by some influential persons, my lord. And the fact of the case are like this, my lord. Your lordship may kindly see Annexure 1.
Prayers are very interesting here, I find, with deepest of humility and the respect to my command. There are certain action which is taken or orders being passed by a statutory authority. If you are aggrieved by an order, you have a remedy somewhere else, but a public interest litigation to set aside a particular order passed under the act.
May I oblige, my lord, but no statutory order is passed.
What are you talking? You are saying that the opposite party aid shall not be directed to recall the letter of such and such. What is this?
Recall is
To keep the revocation of the plan in abeyance.
I am taking a
These are your personal the grievance against a person.
the fact of the case.
No,
Your
but where is the element of public interest?
My lord, I will satisfy your lordship that is a public interest litigation. Your lordship may kindly see Annexure 1, page 32. In the ROR, it was in the Rafiq Khata and Kisam was nature was jungle. In 1979, on the application of one Tejpal Singh, a wetland lease case was registered. And the then Tahsildar granted lease for construction of a factory, industry over that land. But since it was not coming within the purview of Odisha Government Land Settlement Act, then the Tahsildar executed registered sale deed, a registered lease deed for establishing a factory over the land on 13/12/1979. But after getting the lease for construction, he did not take any steps. In sometimes thereafter, some influential person took that Tejpal Singh, which is a proprietorship concern of his industry, to form a company. Then they leave him out. While the matter was thus, in 2022, a conversion application was filed under Section 8A of the OLR Act, alleging that the government, the land is patit, not jungle. And basis on that, it was converted. Then he got a plan approved. And for construction of multi-story building, when it came to the knowledge of the government, your lordship may kindly see annexure,
Then what? Then it came to the knowledge of the government.
government directed
Huh.
to make it Potada and to correct the ROR Potada,
Huh.
directed the collector to initiate proceeding under 3B for resumption of the land,
Huh.
and also directed the BMC, Bhubaneswar Municipal Corporation, to cancel the plan.
Huh. Then
Accordingly, the plan was cancelled. Thereafter, without any reason, without initiating any proceeding for resumption, the plan has been revoked. And now fact remains, my lord. Question remains.
without resorting, I do not know. Plan has been revoked. Then it is a matter between the municipal corporation and the person in whose favor the plan was sanctioned.
Then all in a sudden, my lord, the plan, it has been directed that the revocation be kept in abeyance. But my submission is here, your lordship knows, Conservation of Forest Act 1980, when the kisam of the land is jungle, forest, without the sanction of the central government.
Sir, this conversion was done. If it is done, then you will have to challenge that particular the order of conversion.
That conversion
Sir, this was a episode of 1979 when the lease was executed for the purpose of an industry. Your own case is, and now we are in 2026 and you are trying to upset what has happened in 1976.
In view, my lord, the lease deed is null and void, my lord.
No, it's not. Then you go and assert it. This is not a public interest litigation. This is what you wanted to score your personal thing through a fiat of the public.
It is not personal thing.
This is what is it is an individual's action. If you are aggrieved, you have a remedy somewhere else.
No,
You are not a remedy. PIL. I am asking a PIL. You have seen that we have dictated 2 or 3 judgments just now.
5 acres in Mauja, Pottia, in the main road.
Sir, I am telling you, suppose if they have converted the land. By
Conversion has been set aside.
Oh.
Conversion has been set aside.
Please consider, converted the land by taking an aid of an act. Then if you are aggrieved by order of conversion, then you have a remedy under the act. Secondly, if they have revoked or suo moto recalled the order, if still you are the grievance, you can approach an appropriate forum. I'm talking about a PIL, sir. I'm not talking about other remedies. I'm not talking about PIL. Whether it is maintainable? No. If the lease has been granted, if you wanted to cancel the lease, that also does not come under the PIL. Secondly, if they have they sanctioned the plan for whatever reasons, if you have any grievance, that also does not come under the purview of PIL. If they have revoked the plan, that also is a matter between a person and the corporation itself who has revoked. You cannot come under the PIL. Thirdly, if they have kept the revocation in suspended animation or in abeyance, let us see. That is also a matter between a corporation and the individual. How PIL lies. I am unable to comprehend that the PIL can be used in this fashion.
I'm an individual person for the public.
Even there is a judgment. My own judgment in another High Court has said that so far as the corporation matters are concerned, even a third party, a neighbor or a stranger has a right to challenge a particular action of the corporation, but not PIL. Never.
But here fact remains, my lord. This 79 legislative void ab initio in view of
you are saying then it has to be declared. Now the Supreme Court, you know about it. Even a particular transaction is void, there must be a declaration to that effect. Through PIL declaration. Declaratory degree like a civil court.
As because the lessee did not perform the obligation under the...
That is between the lessor and the lessee. If the lessee has not performed, it is within the competence of a lessor. For breach of the contract, they can terminate the lease.
My lord, order has been passed to resume, but no action is being taken.
How PIL lies? I'm talking of PIL. I'm not talking about any other thing. You may have other remedies. We are not talking about it. Public interest litigation. So cannot be misused in this way, sir.
But your lordship may kindly see, my lord, valuable land in
maybe, sir. Does the law depend upon the value of the cause?
I don't know. 16,600.
Sir, you assert your remedy before the appropriate forum, not through a PIL, sir. Not through a PIL.
Because I am an individual, my lord. I may not take any action in appropriate remedy in appropriate forum, my lord. Servant accept the PIL. And your lordship may kindly see for a moment, my lord.
Sir, are you sure that what you are saying?
And furthermore, my lord, when the action is contrary to law,
Sir, I again say, if any person felt aggrieved, if any person finds that the law is not been respected, he has the right to move before the appropriate forum. It does not foreclose the door, but the public interest litigation should not be used as a tool. What is the public element?
Submission, I may be permitted to withdraw with liberty to.
Not liberty. That is up to you. You can, but we can't say you anything.
But your lordship may kindly appreciate, my lord, the Conservator on Forest Act clearly was the conversion. And conversion is 1925, my lord.
We do not disagree with that, Mr. Bach. We do not disagree with that.
Conversion has been.
Yes.
Long plan from control. That's all. Then we dictate the order.
Only I may be given liberty to pursue. Otherwise, my lord.
No, this is where is a prohibition? Why liberty is granted?
Other courts will not entertain it because if is dismissed or disposed of unless a liberty is given.
No.
Or I may be permitted to ventilate my grievance as per the.
I do not. We are not assuming an advisory jurisdiction, sir. You know it better. We simply percolated our mind into it. It is you. But
illegality is being committed.
Whatever, but public interest litigation, we have to just concentrate on that. The nature of jurisdiction which we are exercising.
But all illegality is being perpetuated.
I am again saying, sir,
because the persons are very
then I give you.
So the problem is that the picker shop is being opened on the land of Lord Jagat.
That's why it's a sentiment, religious sentiment of the people of the
Government itself has closed it in Puri. I have found the document. Government itself has closed it.
Sometime
not expected.
one look at it. Should not happen. So therefore, only 7 days time be done.
To take instruction.
Item 11.
Railway party copy sir. Like a copy sir, OP number 6.
We have
Division commercial manager.
OP number 5.
I will
I have a bad habit of understanding OP number. I am more groomed in an atmosphere where the names are argued. That representing the railway board, I am representing this.
So it's a private party which is
Whatever. So,
but I have got instructions of your
this is a private.
So 4 and 6 are appearing.
4, 5 and 6. I think
5
4
is-
Mr. Mohanty is
This one
appearing.
5.
5 is we.
Four is the private individual, then
5 is
five is
also private.
and 6 is
6 is
it's
railway.
not. It's not.
will-
6 they will.
Yes.
And I think 1, 2, and 3, Mr. Swan, you are representing. You are 6.
Yeah, 6.
Take a notice on behalf of 6.
Opinion received and then submit.
So the copy of 6. Apart from What for?
Mr.
That
Sahu.
in this case, that is item number 52, my lord.
Huh?
That I am appearing for the other side. I am not going to the court since last 2 days because I am suffering from fever. So therefore, I pray that let this matter be taken up
Yeah.
next week any day.
Problem is here, my lord. The revenue appeal was decided in my favor after coming to this honorable High Court. He challenged the revenue appeal in another writ application, which is adjournment. There, my lord, this court did not pass any interim order. The Regional Advocate General Office issued a letter to the my lord, Tahsildar that since the case is pending, you stop operation. Lease was executed in my favor without a stay order being granted by the Supreme Court. They have stopped my operation. My lord.
How can you stop it?
That
Matter may be pending, there is no interim order. How can you stop it?
Your
That is-
lordship,
What kind of a thing is then, I tell you, then why the Malimat committee was constituted and recommended to amend not only section order 41 rule 5, but section 115 also of the Code of Procedure. What was the reason for bringing amendment in 2002, sir? They incorporated that mere filing of an appeal shall not tantamount to stay. 115 also says that mere filing and revisional application shall not tantamount to stay. How can you give a notion without an interim order?
Then notice was issued.
Whatever, sir, that is what I'm saying. There has been an order of the Calcutta High Court also which says that unless there is an express order of injunction or a stay, that does not, you will not stay your hand. How can you issue instruction?
Senior, from the very beginning, therefore, the then my predecessor, sir.
your lordship,
Now I am suffering, Lord. He has
that your
challenged
lordship kindly,
the-
your lordship heard this matter, not the in some day.
I may be allowed to operate. Let him be heard.
Since
no,
when you are not allowed to operate, sir?
In
Since
2022, this
since
letter was issued.
2022.
December 22, I am not being allowed to operate, man.
In
Oh,
Lease deed was
2022,
executed in 2022.
and it is,
Correct.
And immediately thereafter,
it is my
case
affidavit
was
that
filed
he
by-
is never
Then
operated.
how can it be done in this way? You know the law.
Not 2020.
Sir, I think the last time when it was mentioned on your ground, the adjournment was sought. And we fixed the matter today so that
Blood, last time,
we can take. Your client should have taken some kind of steps in this regard.
blood,
This adjournment cannot go on perpetually.
blood, I am only praying, blood, let it be taken off on Monday or Tuesday, any day.
Right.
I am not taking any adjournment because I am suffering from fever.
You should come on Monday then.
Yes, on Monday.
Come on Monday. As a specially fixed matter. Let us see how the Advocate General Office writes a letter. This is not expected.
That the things not.
I understand your predicament, but it is an office.
That issue your
decide the matter on merit.
Whatever is not a merit, anyhow.
on Monday. Blood.
Monday on 2 p.m. Monday.
Specific.
Monday on 2 p.m.
10:30 a.m.
Monday. More. Obliged, man. Greatly obliged. Deeply obliged.
Item number 12.
Well, appearing number 10. Briefed by the
Where is the order dated 26/11?
that is the unilateral cancellation of the works contract.
Where is that order?
Annexure 1, page 10.
Then. Why cancellation, madam? If the period expired, then no question of cancellation.
Yes, ma'am. Let me hand over the instructions from you.
Why you cancel it? The period of contract has expired. Then what cancellation?
This is in violation.
But it is not a cancellation, actually closure. Correct.
Date of
Yes, why you did not complete the contract?
Because of the local issues.
So local issues, that is not there. You'll have to address them and everything is to be done. But if they do a closure, contract ends way back, nothing has been done. 66 trees were damaged by you.
I have paid the compensation.
You have, that does not mean that, no, nothing. He has not done anything. He has not done.
And if at all
The contract has a duration. The purpose is frustrated. You did not ever.
Pending there.
Was there any stay order from the NGT? Then
But there was
no, sir.
pressure upon the contractor.
Nothing of that kind.
you did
God.
not raise that issue also with the authority, then immediately when it was posed before you, you could have taken before the authority. Where is any letter? Where is there? Nothing is there.
You have not raised any issue with the authority. The authority must have taken a consideration. You were just sitting idle. You did not do anything. You were reminded of your responsibility. You did not. Now you can't have a.
Way of the work,
No, no, sir. No, sir. Court is not to substitute the contract for the parties. Can a court rewrite a contract for the parties?
The only ground is because of the local pressure.
No, sir. This is what the first time in the writ petition you are raising. You would have raised this objection before them. You did not. That is what the instruction does not say, that you applied for extension because of this. Nothing. Why you sat over it? No. The instant writ petition is at the behest of the
May I please, your lordship, I may be permitted to virtual mode, my lord. Here is, my lord, annexure 5 is challenged, your lordships. The order was passed when approving the extension of time. He denied the escalation on the ground that the present petitioner filed a no claim certificate for the purpose of extension, my lord. My lord, my humble submission, this order was firstly contrary to the order passed by our High Court in Raghunath Sahu versus State of Odisha, which state that mere filing from the escalations and which is also basing on the Law Department circular. Two, my lord, the Honorable Supreme Court in Radhesham Agrawal case, which was passed from our High Court and straight before SLP, say that while you are granting extension, you don't pass any penalty orders. My lord, this amounts to a penalty, my lord. Third part, my lord, the date of the date of application of extension, the affidavit, they are only related to compensation for the extended period, not escalation, your lordships. Your lordship kindly have annexure 5.
So they have denied your escalation the bill.
Bill on the ground of, my lord, the no claim certificate.
That's
Annexure 5.
understand. Yes, what is your stat? Take instruction next week.
Oblige.
Item 14.
Unavoidably hindered, lordship. There is successor bidder in the petitioner, lordship.
Sucks. Oh.
Though the work was unavoidably hindered, he invoked the clause, condition clause for the purpose of extension of time. Now that was allowed by the executive engineer. It was the learned executive engineer referred it to the assistant chief engineer for consideration.
No. Consideration means what? He has allowed
The extension of time.
So,
but
approval. He has sought for approval from the higher authority.
Approval.
Yes, then?
Thereafter, that was not decided. Approval was not given. I filed a writ petition before this honorable court. Honorable court, while hearing the matter on merit,
Directed him to take a decision.
now on same day, the council AGA submitted a letter that representation has been disposed of, where my lord was pleased to grant me liberty to file fresh application if I am being agreed.
What the represent means? They deny the approval.
They denied the same executive engineer who has approved it and sought for instruction from approval from assistant chief engineer. Same executive engineer after 1 month wrote a letter, since the bidder has not made application for extension, therefore closure. This contrary, lordship, kindly see page 33.
33.
This is the first letter by the executive engineer. Annexure 4, 8/7/2020.
Is recommended be extended till December, 5th December. Then?
Recommended, lordship, got it?
That?
Lordship, then page 46. Same executive engineer, page 40. In inviting a kind representative to subject, it is to state that as the agency has not started during the stipulated period, as per agreement clause, he has not submitted the EOT. Contrary to the lordship, page 33.
EOT means?
Extension of time application, which was granted by the same executive engineer, page 33.
How can it be?
Let's you kindly see page.
This is something. 30?
33 minute.
We are looking at it. Yes.
4 minute.
Yes.
Milord, I have instruction to dispute this document. Let's see, see the bottom, Milord. Let's see the bottom.
Executive engineer?
No, I understand.
Yes.
It is. Lakho.
On behalf of Mr. Prahlad Samant, may I please your lordship?
Why you wanted to quash the tender?
Your lordship, challenging the legality and validity of clause 14 of the tender document, your lordship.
What?
Clause 14 of the tender document, your lordship. And this
Validity.
Page 15.
Yes, your lordship.
The rate is inclusive of GST.
Yes, your lordship.
So
As per the rule, your lordship, that should be excluding of GST, your lordship.
what is the, if they want that you have to include the GST within it, then where is a bar? Where is a bar?
Your lordship, as per the OPWD code.
Show us the OPWD code. Which clause?
In general, in your lordship.
Huh?
I'm not referring to any clause.
You're not. Then in general, you perceive that the OPWD codes that it should be exclusive of GST.
For the required rules, your lordship, the estimate should be excluding of GST.
Sir, it is within the competence of the tendering authority whether to include or exclude. They included it, they wanted in a consolidated sum to be
Yes.
quoted. So
And your lordship, I also want to before the closing of the prior to 3 days of closing of the bid, your lordship, they had issued a corrigendum. Whereby your lordship, that is in Annexure 2, your lordship.
yes.
Whereby your lordship, the online process of bidding has been changed, your lordship, to double cover to single cover bidding system, your lordship.
What?
Double cover system.
Single cover, your lordship. Page number 17, Annexure 2.
And this is before the last date.
Yes, your lordship.
So no
Prior to 3
difficulty.
days.
They can issue a corrigendum.
Divided by all.
What is the difference between a double cover system and single cover bidding system?
The double cover system, your lordship, the financial and the technical bids should be had separately. your lordship.
Have?
The financial bid and the technical bid should be filed separately in double cover system.
Okay.
And in the single cover system, they are simultaneous.
So how it is? What it makes a difference?
Prior to 3 days of
So what? The 3 days time is enough for you to do it. You can exclude the one system, upload the system. There is a difficulty.
my humble information is that
Yeah, have you participated? Not participated.
Petitioner number one has participated, but petitioner number 2 has not participated.
Participated. That's all.
What I want to humbly submit is that your lordship, while game is ongoing,
No, sir. Once the game is played, it cannot be changed. It was not played at all.
Change it.
At least before the toss, the rule has been disclosed. So, no. The petitioner challenges the
I'm questioning the manner of the entire gender process. I'm 175 years, 50 years old. The CM manufacturer.
Yes.
Jute.
Why you want to scrap the entire tender?
Reason being, my lord, I
Actors ground आगे लिखो आगे रख दे. Furthermore, it appears Oh, Wednesday, sorry, next Wednesday.
Item number 17.
Section 1. Order dated 6/4/2026.
Order dated?
6/4.
Order dated 7/4/2026 under Chari. In Annexure 1, the opposite party resigned my contract, madam.
What?
Premature resign.
No, already resigned, na? How premature?
Decision for what is decided?
That's order dated 6/4/2026.
Your contract has been rescinded.
Yes, madam. And
So say resign, you say I was just grappling with the word. What is the meaning of the word resign?
Rescinded.
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 Resign from a contract means your personal act.
I'm sorry, ma'am.
Withdrew.
And the page 23, wherein 20% penalty has been imposed on me of the contractor. The thing is, when I entered into the barrage to execute the contracts, I made a complaint that some of the persons obstructed me to do the work and also demanded 20% of the contract work. I also supplied the photograph of the persons who demanded me in page 34. So also I lodged the complaint before the police.
Yes.
And thereafter, an inquiry was conducted on dated page 53 on 6/4/2026. The inquiry was conducted as per a complaint and you appear on 9/4/2026.
What he was
I appear on 9/4/2026. Was conducted on a complaint on 6/4/2026. And I was directed to appear on 9/4/2026. I am appear. When the inquiry is going on, in between, without findings of the inquiry, they resign me on 7/4/2026. They impose 20% penalty. Whether my complaint is genuine or not, they have to inquire.
Mr. And a handwritten. We are taking a very serious exception. If it is true, what steps you took? Come to page 34. What steps you have taken?
Not the photographs.
What is handwritten?
Yes, ma'am.
So, what steps you have taken?
That's
Do you harbor those persons? Should I take it that you harbor those persons?
An inquiry committee was formed.
Maybe the inquiry committee has not arrived at the conclusion. In the meantime, you have rescinded the contract and imposed the penalty. When a very serious issue has been raised, something has been disclosed.
That's at page 28.
Whatever be, why these steps have not been taken? You are a state, you are representing the state. That includes the police administration as well. What is this? What is this?
Let's permit me to take instructions. What has happened? It's happened. Fine. Let's call it next week.
Just remind us of this. Next week we are giving him a time. Let him take instruction. To take instruction.
Item 18.
Item 18, my lord, we need some file to amendment application. My lord, I 1 week time. My lord, subsequent developments is there, my lord. Obligement.
Ask for a time.
Obligement.
Item 19.
In this tender, under annexure 1, the petitioner is the L1, page 11. His name appears as serial number 1 being the L1. But they have stated, as per the OPWD code amendment, that lottery system is now been removed and there is something, the subjective satisfaction of the officers are the more important. That's why my lord, page 13.
Lottery system is removed.
Yes.
The 15% cap has been removed.
15% cap.
That is what is the difference.
My lord, Before that, that is.
Whether this the tender was floated before that removal or after?
Well, my case before your lordship, that is page 30. Justification for abnormally low bids shall be scrutinized by the departmental technical committee and recommended to the competent authority of the administrative department for approval of the additional performance security, etc. etc.
Correct.
So you have to satisfy why you are L1, why you are L1. That is not abnormally low.
No. Why you are L1 is not there. Why you have quoted so abnormally low the price?
That
is what is.
That is exactly my case.
No, that is what you have not. L1 is different.
I am saying I am not abnormally low, my lord. I have quoted under Annex 5. What is my price? Why I have, because GST has now come down from 28% to 14%, everything. Because I was working there in that Barampur, Ganjam. Then they have issued me Annex 6, page 23.
Yes.
Tender the improvement and you give your realistic price. Once again, my lord. Therefore, page 24. You are hereby requested to submit a realistic price analysis afresh. Realistic price. I have given my quoted price, that why I am at 24% low, and they have given, no, you have to give a realistic price analysis. Then I have given a realistic price analysis, and I have given in page 26, my lord, kindly see. Of India ordered GST in cement from 28% to 18%. That last paragraph I am reading. The union cement rate now from 7 to 8% less. Perhaps this all, everything I have given in realistically, then I have given in my handwritten and also printing. They say, no, this price, we don't think that one can walk in this price, so they have rejected it. Page 35. In view of the above, as per clause 6 of memorandum such that I have submitted before lordship of works department, it raises material concern, so which indicate incapability of the bidder to perform the contract as the offered price.
So you have given a performance guarantee, you have given an additional guarantee. If you cannot perform, they will invoke it.
That's exactly my case. But this is what is in the name of subjective satisfaction.
Now you will say the work has already been awarded, the letter of intent has been given, the work completed. Work
Cancelled, my lord, and it has gone for re-tendering.
Huh?
This particular tender has been cancelled and it has gone for re-tendering, my lords. And the technical bid was also opened on 25th.
Did he participate in the technical bid?
He did not participate.
When the new tender is floated?
The new tender, my lord, is floated on 8th May 2026.
And what is the date of the rejection? 17/4. When?
I have filed on 6/5.
5/5, my lords.
I have filed the base case. When they made that we have come before this honorable court, they have retender. That's not my knowledge, madam. Because this is pending and coming. But this is only to make them accountable. As long as they will not, it is my submission. They are got money, this is abnormally low.
Why you are in hurry, then why you file it with defect? Even a Vakalatnama was not really executed, does not contain a stamp. And you are saying, yes, these are the Vakalatnama not properly stamped, executed and accepted. And then you removed all those defects.
I'm sorry.
You file with a defect and then say, I have come in on 6/5.
No, that's this is not my case. Well, this is not a case that even if they
When, what was the last date? Last date of?
The technical bid is already open, but evaluation process is going on. The technical bid was open in 25/5/2026. That I'm saying up 5th May 2026, my lords. This is as per my instructions.
Now, madam, what to do?
No, 5th May 2026.
They will have to 25th May, she said.
This is why there will be re-tendering when.
Oh, then something is to be done. What do you think?
Madam, I think they should file.
In this, what to do?
Madam, because I am challenging that memorandum that is page 30. Well, that is up to in their hand. As long as they will not satisfied or their PC or their cut money is not satisfactorily done, everything is up.
Oh, I understand, madam. Now, please consider what?
I am challenging this. Your Lordship may say that.
Simply, please,
Your Lordship may issue notice
what? Simply,
and
what? Tell me.
no, if you
Are you not understanding what we mean?
my lord,
What?
I am saying, my lord, no, your Lordship saying that there is no interim order, my lord. I am saying your Lordship
No.
notice.
No.
I will amend my case, my lord, because retendering, I don't know how they have done it.
Do it immediately. Event having taken place.
Authority of Raulkela invited that tender for allotment of running toy train in the Gandhi Park. Now, Lordship, the condition is there must be an experience of 1 year running of toy train. I have got experience of more than 30 years running of toy train. The opposite party
Where?
in Raulkela Gandhi Park.
No, 30 years where?
In Raulkela.
You are already running it.
From 2004, I am running it.
Okay.
I have got the experience certificate, everything.
Then?
Now, while opening the tender, the opposite party did not produce the experience certificate. Now, in the financial bid, he produced the experience certificate, which is belong to district of Keonjhar, that there is no toy train facility available there. I protested that this certificate is false. That was not considered, Lordship.
This experience certificate must be appended along with the bid, or it is to be produced at the time.
Lordship, it is there in kind come to page 11. Eligibility criteria.
Yes.
Lordship, got page 11?
Yes.
Eligibility criteria. Clause 1, subclause B, Roman 1. It experience the prospect.
No. Where is the requirement of submitting the experience certificate, the document?
Requirement they have not disclosed, but it is written here.
No, it is written that he must have completed at least 1 year similar certificate.
Lordship.
And shall produce the proof to that effect. So it can be produced at any point of time.
Any point of time.
So he has produced.
I am questioning the certificate he produced is a fake one. Because in Keonjhar district, there is no third.
Who is appearing for the state?
The opposite party in this case is Steel Authority of India. I have instructions to appear for Steel Authority. I do not have the copy of the.
I'll give immediately.
Give.
Immediately.
I will take instructions on that.
Lordship. In Odisha, there are two train facilities. One is Nandankanan, another is there.
What they are doing now?
It has already been tender has been completed and the successful bidder has already been
Not allotted.
Allotted.
So, like the filing count, not allotted. I am continuing there.
You are continuing?
Up to April, let's see. There, page 53.
page 53, that on 24/3/2026, it was extended in my favor up to 24/5/26. I did mention before Lordship, on the before ensuing vacation, Lordship said it will come after reopening. Meantime, whether they have done it, I don't know. But the factual thing is, if they have done it, it is they have not complied with the tender process, Lordship. That is fake certificate, which is a requirement under this law. Experience certificate.
The instant writ petition.
Procedure finalizing the tender.
You are sleeping in a slumber for a long time, 2 weeks.
I did file before May. Lordship, I did file on May, Lordship.
Whatever be the reason, you could have anyhow. Yes.
In 2025, when he was running the toy train, there was a serious accident also in Rourkela. About 25 to 20 children were hospitalized. Therefore, I feel that
Whatever be, you disclose your.
I'll produce by one.
Item 21.
Item 21 like paper next week.
Last week. Tender has been cancelled.
I will take instruction to the effect, therefore I am saying.
22.
In this present declaration, I'm praying for a direction. I have made a representation to the district welfare officer. The case is, Your Lordship, I was selected under the tender for supply of mattresses to the district welfare officer, Your Lordship. 13,000 odd quantity. That was issued in 16 January 2026. I supplied the entire quantity of the mattresses, Your Lordship. Now, in the tender condition, there is a clause number 22 that whatever the rate which has been approved will be valid for 12 months for the supply of any further quantities. That rate is crystallized for the period of 12 months. So my instructions is that the authority wants to order additional quantities. Therefore, I have made a representation to the district welfare officer that if they wish to collect additional quantities from me, that
Beyond 12 months
not
or within 12 months.
Then the rate may be considered, which is as per clause 22. That is my only request. I made a request.
But your clause says that within 12 months, if any additional quantity they ask for, you'll have to supply with the same rate.
Same rate.
It is only beyond 12 months.
The rate can change.
Can change. Their demand was within 12 months or after 12 months? I am asking you this.
Your Lordship, the period of the supply, initial supply has been completed. Now my instructions is they wish to procure, it is within the period of 12 months because the date of.
There is no such document on record.
It is
Whether we wish to do it or not to do it. And that is not there in record. And para 5, your Lordship may kindly see.
No. Have you asked for any additional mattresses? No.
No.
There is no document. Then what is the grievance?
Purely on presumption. Your Lordship may kindly see para 5 for a moment. Para 5.
My only submission, Your Lordship, if the authority wishes to procure, then they
No, let them not.
Your Lordship, para
Let them not procure. They will not procure from you. Don't worry. He says so. He will not procure from you.
Whether we will procure or not, there is nothing on record to show. And para 5, he has already completed his work. His dues have been cleared. Everything has been done. Now, whether we will procure or not, there is no document.
Yes, ma'am. But how can you insist?
I am not insisting, Your Lordship. I am not insisting.
In case there is a call for this supply, then only.
Your Lordship, I can't seek a mandamus that they have to procure from me. representation in the event they cease.
I think I have spent here for nearly more than 1 year. You have been frequently appearing before this court or this page.
I understand.
You must have understood my views on a representation theory.
I understand.
I do not encourage the representation to be considered and the matter to be disposed of unless I find that you have a legally enforceable right and the right has not been adjudicated by them.
The only thing I am seeking enforcement.
Oh, God.
Lost very good.
No,
That is the terms of order.
there is no order which is placed on you, though no document. What we will do? Show us that they have placed an order to you. I can understand.
Item 23.
Health sector. Against the health sector of the government or health department of the government.
Working that there is very enormous lordship here. Lordship kindly say I am existing operator since 2023. Lordship, that I come to, I am operating.
Where is the provision for extension?
Grateful, Lordship. Lordship, that is page 55. Page 55.
Show us.
Clause 6, Lordship.
Yes.
Period of engagement over the duration of contract. So
Subject-
agency will be engaged in.
No, 3 years, subject to the satisfaction, extended
Yes.
for another 2 years.
2 years.
When your 3 years expires,
Excellent. Lordship.
when your 3 years expire,
The February 26, Lordship.
26.
And my Lordship.
This is a genuine ground for a representation theory.
No, Lordship, then another Lordship protection for me. By virtue of this court's order,
I will not permit you to continue.
Lordship, they will take a decision, Lordship.
Let them take a decision,
Yes,
that's
Lordship.
all.
Let them take a decision.
But-
That's my only.
But no continuance by an order of the court.
By court's order, I am.
If you are continuing, continue.
Lordship, continue.
Probably my
Brother.
lord finger is not
Only
on the
representation to be considered.
Government has taken a
Clause is
decision
there for extension. Page 54. This is right.
The government has the instruction, the government has already taken a decision, not communicated to the, which is not in the knowledge of my current senior.
Okay, extended the time.
Yes.
He is happy, then why you are here?
You have not given a copy of this.
It is already communicated to me.
18.
So, it is not communicated to Mr. Doloi actually.
That's the last paragraph.
For the good reason that if he comes to communicate, what will happen?
The contract is further extended for a period of 3 months. Or till the finalization of the new trend.
That's why, Lordship, I am saying my request is to them, Lordship. If they
Oh, it is
allow-
already considered extended, what more?
Yes.
Yes.
And for consideration of the representation, they filed another representation which is not, our side is not there in this representation.
Oh, they have suppressed with another lawyer,
We cannot say that.
with another lawyer.
Yes, by another lawyer, not by Mr. Doloi.
Mr. Doloi,
In this
your
case-
client appears to be very smart.
No,
Engaging another person for the sales and relief, now engaged you.
See this instruction top,
Hmm.
number is there, in 2026, there,
Where?
top one. And let's even see.
To consider the disposal. What are you doing?
I don't know.
is then he should pay for that. Can you give me that can you? Oh, this writ petition is also here. 23. Which one is we are taking?
Lordship,
23.
18240.
Oh, where is the other writ petition?
I have 2974, Lordship.
Huh?
2974. 24. That is my writ petition, Lordship. I have had two writ petitions. In one writ petition, stay is continued, Lordship. And now the present writ application for
Yes. 2974.
2974.
This was for quashing the termination.
This is not.
And by virtue of this only you are continuing.
Lordship. No, Lordship. Subsequently, they have come up with second tender. I have participated.
And you got it.
Yeah. Lordship. I have. Two nine seven four, Lordship, I quoted the. Quoted, Lordship, that in the order I have quoted.
Or keep this matter along with this matter on next matter. Keep it. I will answer you.
Yes.
Both of them. This one. Okay.
May I please ask?
Yes, sir.
Right, Annex 1, page 13, your Lordships. A quotation called notice for hiring of vehicle was called for by the executive agency. From the reputed travel agencies, our operators, individuals for private loan, registering the vehicles must be in roadworthy condition, newly.
Whatever, the hiring of the vehicles.
Then, my lord, I have pursuant to this notification, I have hired by purchasing a vehicle. You Lordship may kindly see Annex 2 series. I have given those, Annex 2, I have collected the form by paying the appropriate fee. Annex 3 series, my lord, I have purchased a new vehicle.
Okay.
Annex 2 series.
Yeah,
page,
good.
page 15. And you Lordship, page 17, you Lordship may kindly see prior to that, the number was obtained because there is a provision by paying extra pay fee, a number can be registered number can be obtained.
Okay.
So that page 17 I had obtained. I had participated. I was selected as L1 tenderer at the rate of 34,000 per month.
Okay.
Then I was called upon to give the vehicle. You also may kindly see Annex 4, page 20. 22.
Yes.
So I on that day, my lord, I was suffering. Therefore, on the next day, I produced the vehicle on 17. And thereafter, my lord, no decision was taken, and that vehicle, the OP number 4, is actually giving that allotment. I was sorry, OP number 3 was even if I was found at the rate of 34,000 or 34,500, it was given to OP number 3. I have given that. The total selection process I have sought for under RTI, it was not given, and
who is for this thing?
It is Odisha Lift Irrigation Corporation.
This is who dominated it? Is the government of Odisha undertaking?
It's an undertaking, but they have their own set of councils.
Where who
So Panigrahi.
Sir, we were talking today. We are keeping this matter tomorrow. It is we are given to understand
Item number 25.
Seeking permission to appear online, my lord. Please.
Yes.
My lord, inviting indulgence, my lord, there is no dispute per se, my lord. My lord would see the final deviation, which my lord would find on page 190.
100?
190, my lord.
One
My
nine.
lord, the work was of 70 crore plus 6 crore was the deviation, my lord. The main work was completed, certificate given. So for deviation part is concerned, my lord, the deviation was also approved. So my lord would see the operative part, page 192.
Yes.
Last para, my lord, 192.
Yes.
Last paragraph, therefore, considering above facts and figures, the final deviation is being prepared. The final deviation amount is ascertained to be rupees this with a net excess deviation of 6 crore 8 lakh. So, 6 crore 8 lakh becomes payable because this is the addition to the original contract. And this was approved on 11th of March 2025. We sent a representation, my lord, which is on page 205, my lord. Only direction, my lord, that these are nothing, my lord, survives. In fact, these are all admitted figures. And squarely covered by my lord's direction, my lord.
Not disputed. How can, why will not see?
Let's see, it's actually the party is Odisha Construction Corporation. I mean, Odisha has to be there.
Who appears? Issue notice. Issue notice on Odisha Construction Corporation Limited. Yes, issue notice on a Odisha, this Construction Corporation Limited is a government of Odisha undertaking.
Yes.
Yes.
Yes, Lord. On a common water resource department.
Notice, 2 weeks. Give.
Duly obliged.
Obliged.
Item 26.
Appointment 46.
What?
Diagonal municipality.
You are appearing for?
Appointment 4 to 6. 4 to 11. Some liar municipality.
4 to
11, man.
Okay.
I go to directed to sorry.
And sir, copy, but let them stay their hand because Lordship kindly see without Lordship following any procedure of law. And the e-procurement, they have violated the entire guidelines. On the date of opening Lordship, the chairman and vice chairman himself has drawn the lottery and they have selected the lottery. They have awarded Lordship kindly see. Lordship, Lordship can come to page 7-9 for a moment. Lordship, the status says till the bid and technical it is yet to be opened, but they have awarded the works. Lordship kindly come to page 7-9.
From where you get it? They awarded the work.
Lordship, it is online available, Lordship.
Where is that? That they have awarded the work?
Awarded work is to MS6. MS6 page 78. We have approached before collector. All the contractors have said Dharana before the collector of his Lordship. 6 + 15 days. Lordship, because challenging this Lordship illegality committed by this municipality. Lordship, the chairman and vice chairman themselves does the lottery. Lordship, they themselves without fixing date, without opening the price bid, they have selected a person. He will get the work. Lordship, kindly see 7-9. The status says till today, Lordship, the
Sir, what you have done?
My lord.
What is this?
No, that I am it's my instruction, my lord. The process is properly done.
Colonel, why the chairman himself was there?
On the resolution, my lord, the petitioner himself present there on the time of lottery. Everything is there. I have
Show us.
On the footage of that.
If it is there, then no difficulty.
No, everything is serial number 4 is signature there.
Lordship, we are present for opening of technical bid.
Not for financial.
No, no, my final. Then document.
That's a kindly come.
Video camera, there is his present is also marked there, man.
This is for opening of technical business.
He is also.
No.
Total sufficient.
Can you come to page 79?
No.
Can you come to page 79?
No, that is there.
That is the difference. That they may not have uploaded it. They may not have, but this is your signature which is appearing there.
That is for appeal copy.
No,
Can Lordship kindly-
because it is preceded by many writings.
Lordship,
What are you talking about?
Lordship kindly,
No,
please,
you can't.
please come to page 79.
File your affidavit.
Lordship kindly,
No, we are not going to do anything. No.
Lordship, it is glass illegality.
No. Let them. You participated.
Lordship, it is e-procurement. It has to be done in a particular manner.
Whatever.
In a traditional way. Lordship,
Maybe we'll consider.
This
We'll
resolution
consider
will
at
never
that
come
point. Why you participated? Why you did not raise an objection?
Come for tender.
Very good.
I will participate of technical bid,
Okay.
not for financial bid, Lordship.
Which will be done.
2 week, 1 week.
2 days, Lordship says. 2 days, Lordship, 2 days is saying.
No, I read it, sir.
Yes.
Yeah, then how much? In course of this week?
In course of this week.
Yes. Counter affidavit in come.
Item 27.
Let them say their hand, Lordship, because Lordship, can you see? Here, Lordship,
Your signature is there.
Lordship, that is not, that is.
No, your signature.
Present.
That was a lottery what done in your.
Lordship, can this, Lordship?
No,
You agree?
we'll consider that.
Cannot. Lordship,
We'll
that is-
consider why you participated. You were under profound hope that you may be declared.
Please.
Lordship, kindly 1 minute, Lordship, let it.
No,
Lordship, kindly one thing.
no.
No, I'm.
Several technicalities have been projected by the petitioner. writ. At this juncture, we are not going.
Then let's say, can you fix next Tuesday, Lordship, next Tuesday, and fresh admission?
So we have refused the interim order.
Lordship, but Lordship, it is gross illegality, Lordship.
We have said that we'll decide at the time of the decision of the writ petition.
That's why I'm saying Tuesday, Lordship, fresh admission.
Yes.
Tuesday.
Lordship,
grateful. Fresh admission.
Huh? Oh, tender is on Wednesday.
Item 27.
Notice. Before your Lordship issue notice.
Oh, you think that the issue.
No. Before even your Lordship takes up the matter for fresh admission and.
Counter has been filed.
Counter has been filed.
Oh, then it's a implied admission.
So that is why I say, Lord, let notice go, let them accept notice, let the matter be heard.
Very interesting.
We have filed a counter because interim orders would be, it's a tender matter relating to about 320 crores.
Value does not matter.
No, it doesn't.
It's the quality of the grounds which matters.
No, I'm not saying. This technical bid has been
So
rejected.
your
and
Lordship,
we are in the
make
midst
up the matter finally, along with interim also. Since they have filed a counter, we'll file it.
How soon? How soon?
Beg pardon.
How soon you will finally?
Not 10 days time. Let them accept notice. Interim. Finally, your Lordship.
So the matter has come
Your Lordship,
for admission of the instant. Which
this
after 10 days we have already said. Actually, I'm not very accustomed with this system of fixing a date. There we don't fix a date. We simply say after 2 weeks or 1 week. But I have instructed them to give a date immediately after that.
Not the date.
It's not in a habit. That's why. Yes?
We are grateful, dear.
Single word or 2 words? Huh?
28.
Your Lordship, the issue is one of the same, which Your Lordship has decided on last Friday with respect to MCL matter in which the stay was granted. My issue is also the same, that the technical bid was rejected on the ground that I have not submitted a document to substantiate the claim with respect to experience certificate and the performance guarantee. The bid was floated on the GEM tender for the purchase of sanitary napkin up to 38 crores. The bid was opened, technical bid was opened first on 11th of June. On 11th, I was rejected on the two grounds. 19.7 of the ATC, which is page 46 of the writ petition, in which 2 points was raised. One was, there two conditions was there. One was a continuous supply of a sanitary napkin to any government or PSU for the year 22-23, 23-24 and 24-25.
Yes.
I was pointed out of 23-24 that my document does not substantiate the 23-24 supply. And second was performance of 20%. I replied to their notices. I made a representation and I said that I meet both the criteria. On 18th, they have passed the rejection order, which I was preparing for the writ petition. I didn't see the 18th rejection order. And I filed a writ petition on 22nd when the open, saying that reason order was not there and I have been illegally rejected. Now, since I have come to know about the reason order has been passed, I have filed an IA for the prayer need to be amended. And there was one more prayer, Your Lordship, one more IA because a work order has also been issued on 30th of June. So there are two IAs, one IA 12731 for quashing the order and 13402 for the work order which has been issued.
So what is the ground for rejection?
The ground for rejection, now the 18th, they have not replied upon the second point. Mainly, they have accepted my representation. But on the one point of 22-23 that my work does not show, they are saying that I have only appended the work order and the invoices and the supply, that certificate is not there.
Is there any format?
No, there is no format, Your Lordship. If you come to page number 46,
I am looking at page 46. I am simply asking.
Yes, no format. No format.
Then what is to be done? Copies of the relevant contract along with the supply, deriving the quantity, completion certificate, CRAC, and invoices.
Yes, sir.
All are to be submitted.
Yes, sir.
So you have not submitted the.
I have only submitted the work order. Work order was of March 2024. The invoices was of May. My Lordship, what they have accepted is my second one, that is a performance guarantee. If performance 20%, by going there is strict clause, also does not meet their performance one, which they have accepted now. Because in one financial year, it was not there. In one financial year, I was only having 16%. But they have accepted, maybe what I am saying accepted because they have not given a reason for the 20%. So I am of the opinion that they have accepted my representation on that. Going by the strict reading of the clause, even I does not meet that financial year. In this, the financial on March 2024, I was issued the work order. I have continued. There are two clauses, Your Lordship. One says continuity, 22-23, 23-24, 24-25.
Right.
One is continuity and one is performance. Performance, they said, okay. So my continuity is in question.
So that is why if they say that these are the documents you should upload, if you have not uploaded those documents, then what? Then why you will say that they are at fault?
I say, Your Lordship, because...
Why? Because that was a different case where they say any one of the 3 years and they were counting all the 3 years. That was a different case. And he says that if you discard one of it, still I am going exceeding the area. I believe so, if I remember. You are appearing for MCL?
No, man.
So,
I'm for the medical corporation in this case. I think
so that was a different case. But your case is that you have not submitted the documents. What to do?
Your Lordship, the point is, the work order was in March. I started supplying. The invoices was raised in May. So going by, if they say that in one financial year, fine, it is not in one financial year. In 1 year it is. Within 3 months of time, there is
I understand, sir. You are not an illiterate person. With your open eyes, consciously knowing the nuances of the financial year, you participated. Once you participated, knowing fully well that what you have to meet the requirements, you can't come forward and say that since contract was in a previous financial year, supply is affected in the next financial year, it would be taken as a continued supply for that particular year. Cannot be said. Otherwise, it will go against they have defined the financial year, or we have to borrow it from GST.
The first April to 31st March.
What more?
Your Lordship,
And
they
they
have
have also accepted that money.
going by the 20% clause. Your Lordship, they have accepted my going by.
Maybe, but there are twin conditions.
Yes,
Then
sir.
you'll have
My
to,
second condition-
if
my
any
second-
one of the
there
conditions
cannot
is
be
not there.
two reading of the same clause, Your Lordship. In one, they are saying that for the two different years, Your Lordship, once for 20%, they are accepting it. Going by the strict interpretation of theirs only, I was not eligible for the 20% even. So there's two interpretations of the same clause.
He's saying that he has to satisfy that he has submitted same category by 20%.
So acceptance of agency.
So he's saying is a intertwined one. You cannot segregate it.
I'm not saying the segregation part, Your Lordship. What I'm saying is they're highly there.
You are saying that these are integrated with each other. It cannot be separated.
What I'm saying, Your Lordship, is that for 24-25, one financial year only, they have accepted my 20%. Going by their interpretation only, I am not meeting that thing also.
So whatever one wants that condition, but if you do not furnish the document, requisite document, before the last date of before the bid opening date, then where is the wrong on their part in rejecting it?
Your Lordship, the work order and the invoices were within the 3 months period. It is not the financial year.
It has to. Financial year cannot be diluted. Cannot be diluted.
Your Lordship, their reply may be short for Your Lordship. I'm not pressing for any IA. I'm not asking praying for this day. Let them give a reply as to why they have accepted.
You want to remain in ventilator?
As Your Lordship.
It's nothing. I understand there is some substantial point, but if a document is required, if you say that the document is not there, then in that event you can't. Yes.
Okay.
Okay. So I have to rise for some other works. Thanks. All will be carried forward in the next Wednesday.